So I ask again, the Director General of BNI, did you receive any court order accompanying Abronye's detention? If so, can you provide a copy? If not, why did you accept him? The same judge, Circuit Court 9, the Agenda Court, the NDC Court. And let me repeat it. That NDC judge, he must be ashamed of himself. That judge has no respect for his own judicial oath. I don't think he read the law. That Circuit Court 9 judge, I have no respect for him.
Abusiyama mamimo akwaba emma wo adwo aha ene atim famra your platform we in fact I Smart Africa Media kindly subscribe to our YouTube channel so we join here. We're going to discuss a lot today, and today happens to be Monday, the 18th day of May 2026. Now NRA NPP the minority a press conference here. And somewhere what press conference I'm going to play it for you. Definitely you have opinion to make our comment section because I know you're going to want to talk. NPP press conference led by the minority leader Honorable Alexander Kwame Afenyo Markin or Sahin. Now and somewhere press conference in Nebuchadnezzar anoding the issue of NDC arresting NPP for. So the last time I sat here and asked her, why only NPP for? I didn't get any answer from it. But NRA, minority in parliament, a press conference, or they saying, Alexander Kwame Afenyo Markin, minority leader, not doing rough. And some of Wakano. Also one of the worker, that secure judge now, Adenta, where you end this judge, and come away now, bro, you could be a channel. So do you think it is right for Honorable Alexander Afenyo Markin to voice that out as a lawyer? We're going to discuss about it. I need your opinion. Also, Sir Judge, and this was that channel for Juma ways away in a 1 year instead of being a judge for Ghana. But why a judge the NDC and I watch NPP for I see a channel no say Hankwan ya dem krofo ebebra Hankwan na o channel ni. Now, Musa judge and for me, I have no respect for that particular judge, and I will continue disrespecting him until he do the right things. I Smart Africa Media, young Konkoti and Koma a course during the press conference.
A citizen was therefore in prison, not for what he did, but for what he might say. That is not law. That is censorship from the bench. That reasoning is a constitutional disgrace. It is irreconcilable with Article 14 and 19 of the 1992 Constitution, which guarantee personal liberty and the presumption of innocence. A judge who denies bail because an accused may continue to express political opinions has not administered justice. I say what I'm about to say as a practicing lawyer. As someone who has spent his professional life in courtrooms, who has profound respect for our judiciary and deep admiration for those who carry the weight of dispensing justice, I say this not in anger, but in fidelity to the Constitution I have sworn to uphold, and with all the candor, humility, and respect I can command. When a court denies bail, not to serve justice, but to serve silence, it has administered political censorship from the bench, and that, with the greatest respect, is a betrayal of every principle that gives judicial office its authority, its dignity, and its legitimacy. Now, let me specifically deal with the nature of the remand. It was a BNI remand, and indeed, even so, there is a missing court order. No court order drawn. Every remaining doubt about the political character of this prosecution is removed by the decision to remand Mr. Abronye into BNI custody. The BNI, by law, is Ghana State Intelligence and Security Service. It is not a remand prison. It exists to address genuine threat to national security. Mr. Abronye posted a critical video about a judge. That is not a national security matter. It never was. This has nothing to do with the criminal justice and everything to do with political intimidation. But there is something even more alarming. I want every Ghanaian to hear this clearly. Even those who hate the guts of Abronye must at least listen to this matter. It has now been 4 days since the court pronounced the remand order. 4 days, as I understand it, on the basis of information available to the party at the time of this statement. Counsel moved up and down the courtroom, the registry, demanding for certified remand order. The court order, as at Friday, has still not been drawn. I therefore simply ask a simple question. On what legal basis did the Ghana Police Service take Abronye into custody and conveyed him to the BNI? On what legal basis did the BNI accept and held him? A remand order is not a verbal instruction. It is a formal judicial instrument. It is a written legal authority upon which the deprivation of a citizen's liberty must rest. Was a Ghanaian citizen delivered into intelligence custody or nothing more than a word of mouth? If so, that detention has no documented lawful foundation whatsoever. So I ask again, the Director General of BNI, did you receive any court order accompanying Abronye's detention? If so, can you provide a copy? If not, why did you accept him? And I ask my Lord, if my Lord thinks he is bold enough, why is he running away from his own court order? By the way, that Circuit Court 9 records are immediately tied. As you are making your submissions, the clerk is typing. So within 5 minutes after court, the records of court must be ready. Why has it taken days? And as at close of business Friday, the order was still not ready. What is the judge trying to tell us? Is he trying to change what he has said in open court? That Abronye should remain in custody until the case is finally determined, not even to the next agenda date. His language was clear. Is he running away from his own language? Is he afraid of public outrage against his own conduct? Article 14 of the 1992 Constitution requires that no person shall be deprived of his personal liberty except as permitted by law, and that every arrested person shall be informed immediately in a language he understands of the reasons of his arrest. The Constitution therefore puts before the Ghana Police Service, the Bureau of National Investigation, as well as that Circuit Court 9, which was supposed to be presided over by a judge who has taken a judicial oath, a clear and unambiguous notice of the civil liberties provided for by the Constitution. These are rights guaranteed, far rights. The production of a signed and certified remand order is not a technicality. It is a constitutional imperative. Its absence, if confirmed, would rather render this detention not merely improper but unlawful. What we are witnessing is either a crass dereliction of duty or a raw and deliberate exercise of power designed to show a political opponent where the power lies, with due process and afterthoughts. So the NDC party functionaries who are encouraging this, you should know that your 4 years is now left with some 2.5 years. Your time will come. Those judges should know that President Mohammed's tenure will soon come to an end. They should know this, that God willing, 2028 will be Dr. Bawumia's turn. Indeed, we are reminding them that neither explanation is acceptable in a constitutional democracy. Both demand accountability. Now we see the ghost of criminal libel coming back, buried by Kufuor, but resurrected by President Mahama. There's a deeper dimension to what this government is doing, and it must be named plainly. On 27 July 2001, Ghana's parliament unanimously passed the Criminal Code Act 2001, Act 602, which repealed the criminal libel and seditious laws. President John Ajekum Kufuor gave his assent on 2nd August 2001, striking from our statute books one of the most notorious instruments of state censorship this country had ever known. That repeal was a defining moment in Ghana's democratic maturation, a declaration that in free society, the state has no business imprisoning citizens for what they say. The bill was presented to Parliament by Nana Addo Dankwa Akufo-Addo, the Attorney General as he then was. The world applauded. Ghana was held up as a model for Africa. But before we go further, let me be precise about one important historical fact. The criminal libel law was not created by the PNDC or NDC. It is a colonial inheritance drafted in 1893 by the British colonial administrators and embedded in our statute books to suppress dissent against imperial rule. Dr. Kwame Nkrumah, our first president, inherited it at independence. It was codified in our Criminal Offences Act 1960. The law predated the Rawlings era by decades. But what history will never forgive the PNDC and NDC for is this: they weaponized that colonial relic most ferociously, most systematically, and with the greatest cruelty against the citizens of a free Ghana. Under PNDC military regime of Jerry Rawlings, journalists, academics, lawyers, trade unionists, and ordinary citizens were arrested, detained without trial, and tortured for daring to speak. The culture of silence was not a metaphor. It was a lived reality enforced by brute state for power. Mr. Tommy Thompson, publisher of Free Press, and Mr. Michael J., a senior writer, in 1982 were among those imprisoned without trial for editorials critical of the PNDC. Mr. John Kublenu, the editor, was separately arrested in 1983 and detained without charge before being transferred to Nsawam prison. He died in 1984. Shortly after his release, his health destroyed by the conditions of his detention. He was never charged. He was never tried. He simply died for daring to write. Tommy Thompson himself continued to face harassment and repeated prosecution and died in 1998. His death, a direct consequence of brutalities he endured in his long fight for press freedom. 2 men, 2 deaths. The blood is on the hands of that regime. Abdul Malik Kwekubaku Jr. was arrested and tortured under the PNDC. He has spoken publicly about being made to crawl the full length of Military Parade Square on his knees until they bled, about being caned on his waist, about 25 days at the Fields Engineers facility that left him physically impacted, about losing control of his bodily function for days on end, all for speaking truth to power. Kwesi Pratt Jr. was jailed and tortured during that same period. So was Akotampa and many others whose names history has not fully preserved. Then came the NDC in constitutional form. And even under the democratic dispensation, the party found uses for the criminal libel law it had inherited. On 23 July 1998, two of Ghana's most respected newspaper editors, the same Abdul Malik Kwekubaku Jr. of The Guide and Alhaji Haruna Atta of Weekend Statement, were convicted by the Court of Appeal and sentenced to 1 month in prison. Their crime? Publishing a story about the former First Lady. They were dispatched to separate prisons, Akuse, Winneba, and Anumabo, in a deliberate attempt to break their spirits and prevent visits from supporters. Images of Kwekubaku and Haruna Atta in handcuffs being marched to prison are etched in the collective memory of every Ghanaian who loves freedom. In 1996, editors Nana Kofi Kumsin of the Ghanaian Chronicle, Ebenezer Kwaku, and Tommy Thompson of the Free Press were arrested and charged with publishing false news with intent to injure the reputation of the state. Those exact words, publishing false news, the same statutory weapon this government is now deploying against Abronye. And when the court came to repeal the criminal libel law, the then NDC chairman, Obed Yawasamwa, who had also served as Attorney General under Rawlings government, declared publicly that the law could be repealed over his dead body. Over his dead body. That is the NDC's historic relationship with free speech. That is the tradition President Mahama now chooses to continue. The MPP abolished the law that the NDC swore to keep. And now the NDC is quietly rebuilding what the NPP tore down. Now the Mahama administration, unable to openly reverse that landmark reform without international condemnation, has chosen a more cunning path. Rather than restore criminal libel by name, it is reconstructing the criminal libel regime in practice, hiding behind sections 207 and 208 of Act 29 to achieve through the back door what it cannot defend through the front. The charges against Abronye, Baba Amando, David Esando, and others are in substance and in effect criminal libel prosecutions. The only difference is the label on the charge sheet. The intent is the same. The mechanism is the same. The consequence is the same. Arrests, remand, imprison, silence. President Kufuor abolished criminal libel to set Ghana free. President Mahama is rebuilding it brick by brick to cage opposition. So I ask President Mahama, is this the legacy your second coming is leaving Ghanaians with? I pray it is a no. When civil remedies exist, criminal prosecution is a political choice. I repeat, when civil remedies exist by law, criminal prosecution is a political choice. And that is the choice this government has made. I made this point earlier in these proceedings when I started. And I return to it now because it deserves to be stated plainly and in its full legal force. Ghanaian law already provides a civil remedy for any person who genuinely believes they have been defamed. It has always been there. It exists today. The aggrieved party may approach the civil courts. They may sue. They may place their case before a judge. They may walk away with their reputation vindicated and with damages in hand. Not a single arrest is required for any of that. Not a single bail application. Not a single remand into BNI custody. The civil law achieved the stated objective, the vindication of reputation, without any of those consequences. This government knows that or ought to know that. Its lawyers know that or ought to know that. The prosecution officers know that or ought to know that by their training. And yet, case after case, the criminal route is chosen over the civil one. That choice is not a legal necessity. It is a deliberate political decision, and the purpose it serves is not the vindication of any reputation. It is the suppression of voices. When you want to protect your name, you go to the civil courts. When you want to punish and silence an opponent, you send the police. This government has made a choice, not once, not twice, but repeatedly and with the purpose. The Ghanaian people can see it exactly for what it is. Now we can see a pattern, not an incident. Ladies and gentlemen of the press, let no one tell you this is an isolated case. The arrest of MPP members for things they have said or posted in public are too numerous to catalogue here. We have documented case after case since this administration assumed office on 7 January 2025. The list grows longer by the week. Let me mention just a few. David Esando, MPP Aguna West constituency organizer, arrested by approximately 10 armed national security operatives. His crime? Posting an image of President Mahama with the caption "Doomsaw is back." But isn't Doomsaw back? 10 armed officers for a Facebook post about electricity outages afflicting millions of Ghanaians. Then Mr. Abubakar Yakubu, MPP Sunyani East Communications Officer, popularly known as Baba Amando, arraigned before an Accra Circuit Court, remanded, charged with offensive conduct, false publication and circulation of statements likely to incite fear and panic. The same judge, Circuit Court 9, the Agenda Court, the NDC Court, and let me repeat it, that NDC judge, he must be ashamed of himself. Mr. Alfred Abebi Okumi, known as Adenta Kumi, was arrested by operatives of the National Investigation Bureau in a dramatic dawn raid on his home. His wife suffered a miscarriage as a direct consequence of that raid. His crime? Submitting a petition to the president concerning the conduct of committee members sitting on the Chief Justice removal proceedings and making comments in media interviews and on social media about the same matter. He was formally charged with publication of false news under the same statutory provision being used against Abronye today. And there's a case of Reverend Intim Fojo, a member of Parliament for Asin South, and a ranking member of Defense and Interior Committee of Parliament. This is a sitting member of Parliament, a duly elected representative of the people. Again, BNI operatives attempted a raid on his residence after he raised concerns about 2 aircraft that visited Ghana and alleged possible links to drug dealings and money laundering. It took his colleagues in the minority caucus to physically resist attempted arrests. Dr. Baumia, our flag bearer, himself had to visit him to reassure him that a member of parliament should require reassurance that he remains free after raising matters of national security concern in the discharge of his public duty is a statement of the most alarming kind about where this country is headed. And now Abronye, remanded into BNI custody for criticizing a judge. There are no isolated incidents. They are selected examples from a deeply troubling and growing list. That judge has no respect for his own judicial oath. I don't think he read the law. That Circuit Court 9 judge, I have no respect for him. For a judge to say that he's remanding Abronye into BNI custody until the case is finally determined, such a judge can never have my respect. I pray that he summons me for contempt. I will continue to disrespect him until he upholds the law. He's gone beyond his judicial function. And it is not his first. It's as if he has been He has been selected purposely to achieve this. He doesn't talk law. I don't know whether he ever passed his law exam. It's a shame. It's a shame on the judiciary. And my Lord Bafuboni must pay attention to this. For whatever it is, it's about his legacy. I'm told by December he will be 70 and he will be gone. Is that a legacy he wants to leave? After Tokonu was booted out of office and all manner of accusation leveled against Tokonu, is that the judiciary? The judiciary, they said they were going to reset. Is that a reset where a judge will say he is remanding an accused? Because if he allows him to go home, if he grants him bail, he is likely to talk again. So he should remain in custody. In fact, at first, his pronouncement was that Abronyo should go to Insawom until the case is finally determined. He's already prejudiced the outcome of the case. And this man says he's a judge. I should respect him. No way. And Sanfu say, Edietri. Eyenim gwase papa. Ebufusem. More fire. Our flag bearer, Dr. Muhammadu Barumia, has rightly described as an unholy collaboration, this conduct, between the executive, state investigative agencies, and some element within the judiciary aimed at silencing the MPP. He is right. More than right. The pattern is undeniable. This is state-sponsored political persecution, and it must stop. Now, a word to the judiciary. You are to be the guardian of liberty, not instrument of power. I now address you, my respected learned members of the bench, and I've used respected advisedly. And I do so with gravity. This moment demands. The 1992 Constitution, my lords, vests judicial power in your hands as the judiciary and charges you with the solemn mandate to be independent guardians of the rights and liberties of the Ghanaian people. Article 1253 declares that judicial power of Ghana shall be vested in the judiciary. Article 127 fortifies that with the guarantee of independence. These are not ceremonial provisions. They are the constitutional foundation upon which every citizen's liberty ultimately rests. It is with the deepest concern that this party NPP observe how the courts have conducted itself in this matter. A bail application grounded on orthodox legal principle was dismissed on a basis that no serious reading of Article 14 and 19 of the Constitution can sustain. A citizen has been remanded into the custody of an intelligence service on misdemeanor charges. What has happened to the old principle of law? That should all men find a man's hand in a till, his guilt must be proven. Under his lordship, Bafuboni's leadership, you are guilty before you are pronounced guilty. You are guilty before full trial. So my Lord Bafuboni, Embredudua waye judge, anyamia dum, omutu Tokonu yaya ubedi chief justice. Sadia wena wudija Ghana. Eye ningwasi o my Lord. Bieweni neshe de ekofom, ekoso wo fomo. Se judge otumika se obi nko remand. Se yebedi na se mewie. Ekumu inamu enimu ase. Supreme Court judges, Court of Appeal judges, High Court judges. Monsore nkasa. Na de ekoso nu ekumu inamu enimu ase. Eye de mwa mubegu mu hufi no. Ye mpampa mu ye be kasa, mu pia mu remand yen. Mu pia mu nka contempt na mu fa yen ko prison. Ye be ko inso. Ye na nanu mu omode party be bo ase no. They went through similar ordeal. It never broke them. At every turn, the scales have tilted not toward the protection of liberty, but toward its curtailment. A court that allows itself to become a tool for silencing political opponents has ceased to be a guardian of liberty. It has become a participant in its destruction. I am aware of the climate in which our judiciary is operating. I am aware that this is a government that has shown it is capable of defiling our constitution to haul a sitting chief justice out of office. I am also aware that some members of the judiciary may be afraid. They look at what was done to Chief Justice Tokonu and ask themselves whether standing up for the constitution is worth the personal costs. I can understand that fear. But there are some also who are still wearing partisan colors and are refusing to look at the law, and they are bent on taking backdoor instruction from the executive to do their bidding. Those must change their attitude and respect the human rights of every Ghanaian, irrespective of their party color. The people of Ghana look to the courts as a last line of defense when the executive overreaches. The trust is earned by the fearless and impartial application of constitutional principles, especially when the person before the court is politically convenient to those in power. A judge who surrenders to fear and becomes a timorous soul, too intimidated to defend the constitution and the rights it protects, is no longer a judge. He has become an instrument of the powerful. A court that reserves its constitutional courage for safe and inconsequential cases and abandons it precisely when it matters most has dishonored the robe. I call upon the High Court to take urgent cognizance of the circumstances of Mr. Abronye's detention, including the reported absence of a signed and certified remand order, and do the needful. Now, Ghana has been here before. The culture of silence does not announce itself with a decree. It does not arrive at your door with a proclamation. It arrives as likely like this, incrementally and surgically. A communicator of a party is arrested. An organizer is picked up there. A regional chairman is remanded into security remand. The message spreads quietly through every rank of the opposition. This is what dissent costs. The Mahama administration has calculated that intimidating MPP communicators and silencing its regional leadership will allow it to govern without accountability and shield its mounting incompetence from scrutiny. That calculation is profoundly wrong and it will fail. It will not work. The MPP will not be guarded, not by arrests, not by bail denial, not by BNI detention, not by any instrument of fear this government deploys. The freedom to speak, to criticize power, and to hold governments accountable is not a privilege granted by any administration. It is a constitutional birthright, and it cannot be revoked by any government on earth. Abronye's voice may be temporarily caged. Let the government understand clearly. 1,000 voices will rise in its place. And that is not a threat from the party, but rather it is the unbreakable promise of Ghanaian democracy we are reiterating. Now our demands. We make the following demands, and they are non-negotiable. First, Mr. Kwame Bafo Abronye might be relieved from BNI custody immediately. His detention is constitutionally indefensible and must end today. Second, our legal team will mount full constitutional challenge to this prosecution, including challenge to the application of sections 207 and 208 of Act 29 against political speech where civil liberties are available and adequate. Third, Parliament's Constitutional, Legal and Parliamentary Affairs Committee shall, upon assumption of Parliament, be made through an application to summon the Inspector General of Police, the Director General of BNI to publicly account for every decision taken in this matter. The Chief Justice is not also above the law. Parliament will use every law under its command to summon the Chief Justice. They must all be answerable. And let the majority know this. In the effort by the minority in ensuring this is done, they should not try to stampede it. It is good for democracy, and we call on the majority to support it, because tomorrow they may be in opposition and they may need this very law to protect them.
It is serious. A conversation be one. Me say be no take kakra. But how kind of style be? For Alexander Afenyo Markin, kase wo mujaje no kete kura no sound so and I said no de ma make kura. Though there are some things here so I disagree with a lot of many cases here. They are do papa dem. One, me say this man in komo emi ndai dida. They are watching wo Gomua West. Abrantia no watching NPP constituency organizer no watching. Some komo me ndai dio. Me ndai because it still doesn't sound clear to me. Still and sound clear to me. Why would you arrest that guy? And I think that enona abu bomo crack no mo I feel the akoko pisa. And Afenyo Markin is speaking. I know, sir, he's pissed off. I didn't work also me catching this for say. So we end this near Mr. Emma winning the arrest of NPP for 1 year arrest him, because definitely power might change one day, and it is going to turn to you. Obi because I and Omonso they did say, and that is why Ghanaians we are not growing. That is why the country called Ghana, it was 60 something years. The country is still not growing. That is the problem. That is the issue. That is the issue. Afenyo Markin, a lawyer, a very professional lawyer. What in a court, them what tina. So I think sir, on one case when him say you're betting for contempt, but he is ever ready, because and so where trema pointed at the war. Or say I'm ready, and I'm praying say they will call me for contempt, and I'm ready. For Afenyo Markin to voice these things out. And one thing I meant to say, lawyer for no more platforms. Say young funding because he died or baby can somewhere change. Is that the right thing to do as a judge? Me nim wasn't until Mr. Montrem Secacra. Young concording comment section. I certainly welcome your opinions. As South African Media, kindly subscribe to your YouTube channel, like Nafi Science Shema for Brown with Teaching Benty. That is me opinion. Yeah, me matcha imagine say it doesn't sound well. For say you're in charge in the BBA, you say uncle trim or trim we are uncle trim because you die no or be kwa kika. What I mean so let's understand this very well. Me pancho montra me aseka. Is it right to do that? Me didn't edo the man come about na ko for